Okay, good evening everyone. Let's get started. We're very lucky and privileged to have Dr. Ralph Wilde with us tonight. Ralph needs absolutely no introduction. Is one of the superstars of international law. You really have here a big shot, so I'm so happy that we have such a nice turnout tonight. Ralph is known for his scholarship, but also for many other things, but his scholarship has been particularly influential with respect to the territorial administration of territories, and his book, published by Oxford University Press in 2008, got the Certificate of Merit of the American side of international law, which is a very prestigious prize. Recently, Ralph has been devoted his work to the extraterritorial application of human rights, and in that area too, Ralph has proved very influential. I do believe that what he's going to speak about is kind of an offspring of his work on international law and in human rights law beyond border, which is a project for which he received also a very prestigious grant. So today Ralph is going to speak about beyond sovereignty. I think that's the nice polemical title you've given to this lecture, and you'll be focusing on the case of overlapping jurisdiction. Ralph is actually a regular visitor of the Manchester International Centre. I do think that this is your second talk in the last years, so we're very privileged. You see that we are always upgrading our lectures. Now, thanks to the help of John Haskell, we are recording our guest lectures. I would also like to thank John, of course, for setting this up, but also Cara, who was very helpful in organizing this event. I'm very pleased to see many LLM and master students in the room, together with colleagues whom I thank, and members of the Manchester International Centre. So Ralph will be speaking for 30-40 minutes. There'll be then plenty of time for discussion. This is your chance to engage with a great scholar, so I hope you seize it, and the talk will be followed by a small reception. Ralph, you have the floor. Thank you. Thanks again for coming to Manchester and struggling despite the traffic. So, you have the floor.
Thank you very much, Jean. It's a great pleasure to be here back in my hometown, and also at this wonderful university at the great Manchester International Law Centre. So thank you very much to Professor Ian Scobie, Jean Dascoumont, and also now joined wonderfully by John Haskell. It's great to be here. Now, as we know, in 2 days' time, on the 2nd of November, is the 100th anniversary of the Balfour Declaration. And one of the most significant normative developments in international law that took place over the course of what we might call the Balfour century is the development of international human rights law, which has, of course, its origins in the protections supposedly accorded to people living in mandated territories, which Palestine, that the Balfour Declaration related to, was, of course, one. Now, the acceleration of globalization over the course of the Balfour century has also underscored how a conception of global governance based solely on mutually exclusive sovereign states can't accommodate authority exercised by non-sovereign actors. And although human rights law has for some time made way for non-sovereign responsibility in some circumstances, fundamental problems and tensions remain underexplored and unresolved. In particular, how can and should substantive obligations in human rights law be calibrated between the different actors involved when more than one actor exercises authority over any given situation? Today, I'll focus on one particular situation where this problem presents itself, when one or more sovereign actor in the form of a state acts in the sovereign territory of another state. In other words, situations of the extraterritorial activity of states. Examples would be the occupation of the Palestinian territories by Israel, which of course this year marks the 50th anniversary. The occupation of Iraq by the US-led coalition, including the United Kingdom, following the removal of Saddam Hussein in 2013. The unlawful annexation, and so as a matter of law, actually the occupation of Crimea by Russia, as well as Russia's support for separatists in the Donbass area of Ukraine. In situations such as these, how can and should obligations be divided up between host and foreign authorities, between Israel on the one hand and Palestine on the other, between Iraq on the one hand and the US and the UK and other states on the other, between Russia on the one hand and Ukraine on the other? Originally, this issue, for example, when it came before the European Commission, as it was then, and Court of Human Rights, concerning the Turkish presence in northern Cyprus, the issue was approached in a simplistic fashion through concepts of effective overall control, where the nature of a state's presence extraterritorially and the consequent regime of responsibility is understood as a sort of analogue to the presence of the state in its own territory, in that the approach focuses on situations where the host state is removed entirely from exercising de facto authority in favour of the foreign state, with a consequent regime of responsibility that focuses exclusively on the latter, the foreign state, and not at all on the former, the host state. More recently, certain cases on the issue have moved beyond this to consider how responsibilities might overlap. For example, the ISA case before the European Court of Human Rights addressed the responsibility of both Russia, the foreign state, and Moldova, the host state, in the context of Russia's support for Transnistrian separatists in part of Moldovan territory. Similarly, now that Palestine has acceded to most of the main human rights treaties, the treaty bodies will have to grapple with the question of how its legal position in those treaties is bound up with that of Israel, insofar as both states play a determinative role over the human rights situation in the Palestinian territories. And as at the time I deliver this lecture, this issue will first of all be addressed by the CEDAW Committee. The human rights bodies will have to grapple with how the determinative role of the two states on human rights varies considerably, both as a matter of the formalities of the Oslo agreements and the realities on the ground, as between Gaza, areas A, B and C of the West Bank and East Jerusalem. Now this lecture, as Jean mentioned, forms part of a research project, Human Rights Beyond Borders, which involves a critical interdisciplinary investigation into the extraterritorial application of human rights law, covering civil and political rights and economic, social and cultural rights. The project is funded by a frontier grant from the European Research Council, which is the academic funding body of the European Union. So thank you then, European Research Council, and indeed thank you, European Union. The project website contains all the outputs of the project produced to date, and further publications will include coverage of this question of how the applicability and responsibility regime of human rights law should be calibrated as between the host and the foreign state. All outputs are and will be open access. What I'd like to do today is address a prior fundamental matter which is of essential significance to the extraterritoriality topic in general and the issue of overlapping responsibilities in particular. This issue, however, has so far been almost entirely overlooked, certainly when the matter has come before courts and other interpretative bodies such as the international human rights mechanisms. However, an appreciation of it is crucial in providing important new pathways into a better appreciation of what is at stake and how this should mediate how the law here is understood. What I want to focus on are political and legal ideas about the legitimacy of the foreign state's presence extraterritorially in and of itself. How these ideas relate to what are in many ways mirror opposite ideas about the legitimacy of a state's presence in its own territory, and how the dialectic between these two sets of ideas plays out when considering the dialectical relationship between the responsibility of the two states in relation to the human rights situation in the same territorial area. Now, in order to underscore the relevance of what I'm about to say to actual instances of extraterritoriality, I'm going to use the particular situation of Israel and Palestine as a case study. In this year of the 50th anniversary of the occupation and the centenary of the Balfour Declaration, international lawyers should reflect on the role of their discipline in this situation, and it's hoped that the present lecture will play some part in that. Now, before I can address the relevance of ideas of legitimacy to the topic of overlapping authority in extraterritorial situations, I have to flag up one general feature of human rights law, which is crucial to the topic and often ignored or at least misunderstood in relation to it. Most human rights obligations, beyond non-derogable rights, are conceived in a manner that permits limitations on these rights, utilising relational tests requiring a legitimate purpose in relation to which a restriction must be necessary and proportionate. It follows then that beyond non-derogable rights, human rights norms are conceived to mean different things in different contexts. Flexibility and contextualization are integral components of the very meaning of the obligations themselves, via the operation of various mechanisms which permit these restrictions. So to have the same obligations apply in different situations does not necessarily result in identical requirements in terms of the particular policies promoted in all cases, even if identical minimum standards operate. Context is therefore key. What then is the relevant context when it comes to extraterritoriality? What does international law, including human rights law, say about it? And what is the effect of all of this on the substantive meaning of human rights law for the host and the foreign state and the interrelationship between their obligations? Now, the territorial-extraterritorial distinction is based on a fundamental difference in the political nature of the state's relationship to the people involved, from which flows special legal entitlements and obligations, both domestically and internationally. In its territory, so Palestine in the Palestinian territories, Israel in Israel, the state is sovereign, with corresponding entitlements and obligations. Necessarily, the state lacks these sovereign entitlements and obligations extraterritorially, so Israel in the Palestinian territories, where they are the exclusive domain of another state, in my case study example, Palestine. Quite apart from issues of state sovereignty is the law of self-determination, which concerns the right of people rather than the sovereign rights of the state. Under Common Article 1 of the two global human rights covenants, a people have the right to, and I quote, freely determine their political status and freely pursue their economic, social and cultural development, end of quote. As with sovereign entitlements, these rights similarly operate profoundly differently in the territorial as opposed to the extraterritorial context. So territorially, Palestine in the Palestinian territories, Israel in Israel, the state is required to be of and for the people of its sovereign territory as a self-governing polity. Extraterritorially, the state, so here Israel and the Palestinian territories, is in an opposite position to this, enjoying no legitimate right to exercise authority over the local population. The effect of the obligation in Common Article 1 of the Human Rights Covenants is that Israel's actions in preventing the Palestinians from full self-government and independence is illegal. Israel is subject to an obligation to allow and enable the Palestinian people to run their own affairs, free from outside, notably its interference. This is the legal basis for the obligation Israel has to withdraw from its control over the Palestinian people, to end the occupation. Moreover, the fulfillment of this obligation, or put differently, the realization of Palestinian independence through full self-administration, is something that should be realized simply by virtue of the right of the Palestinian population to have this situation brought about. One of the most important normative shifts that occurred in the Balfour century was in how the colonial era idea that independence for certain people should be realized only if and when they're deemed ready for this, in terms of their stage of development. This idea, which was at the heart of the mandate arrangements, was repudiated and delegitimized halfway through the Balfour lifespan by the self-determination entitlement. So as holders of this entitlement, independence is now an automatic right of the Palestinian people, not something that is earned depending on the level of development. As articulated in the seminal formulation by the United Nations General Assembly resolution in Resolution 1514 of 1960, and I quote, "Inadequacy of preparedness should never serve as a pretext for delaying independence," end of quote. What then do human rights obligations require extraterritorially that is different from the territorial context? And what do they require territorially for a state affected by the extraterritorial actions of another state? Well, as mentioned, the self-determination entitlement and obligation requires Israel to end the occupation, transferring authority to the Palestinian people in a precipitous manner, just as in the situation of the occupation of Iraq, the end of that occupation was something legally obligatory on the US-led coalition, not just a matter of its own personal discretion and policy. Equally, Palestine must take all necessary steps to do all it can to bring about the realization of self-administration by the Palestinian people, including through the end of the occupation and the provision of effective institutions of self-government where this is possible. These requirements are based on capacities, leading to very different consequences in terms of what must, in substance, be done or not done for each of the two states in any given situation. Because this right of self-determination is contained in the two global human rights covenants, this is a human rights obligation on the part of the extraterritorial state of Israel and also on the host state, Palestine, quite apart from it forming part of general international law. Beyond this general requirement, the question then arises as to what the other substantive rules of human rights law mean in the territorial and the extraterritorial contexts. Given that the law of self-determination is regarded as having Jos Kogan's non-derogable status, the other norms and doctrines of human rights which lack this status, which would be most of them, the other main norm with this status is the prohibition on torture and human and degrading treatment. These other rules have to be interpreted so as to be consistent with the meaning of the self-determination entitlement. Given that, as I've mentioned, this meaning is different as between the territorial and the extraterritorial context, then other areas of human rights law have a correspondingly divergent meaning as between the two contexts, because of the mediating effect on them of the self-determination entitlement. Thus, understanding Israel's general human rights obligations in the Palestinian territories, in the light of its general obligation concerning Palestinian self-determination in particular, requires a different interpretation of these other human rights obligations as they apply to Israel as a foreign presence, compared to their meaning to Israel at home, as it were, where Israel is sovereign, and equally to their meaning to Palestine in the Palestinian territories, where it is the sovereign. How is the meaning of the other human rights obligations then different between the two places? In general, everything must be in step with the self-determination entitlement, and appreciate how it cuts differently in the two contexts. The starting point is the overall means through which human rights is implemented nationally. Human rights law requires an effective functioning territorial system that can secure all the substantive rights. Given that it's accepted that human rights law can apply extraterritorially, then in principle either the home or the foreign state, or some combination of the two, could deliver on this requirement. However, because of the effect of the self-determination entitlement, the two possibilities are not equal. Under the law of self-determination, people are entitled to be self-governing. It follows then that the structure which guarantees their rights should be that of their own state, not a foreign state. Overall, this amounts to the same requirement as the earlier, more general self-determination entitlement of the Palestinians to self-administration, and the concomitant obligation on the part of Israel to transfer authority to the Palestinians. This is required then as a matter of the rights of the Palestinians to run their own affairs and to have their human rights secured by their own state. Insofar as power is being transferred to it, or is otherwise exercised by it, Palestine has an obligation to build up an effective system of human rights protection. This requires considerable, wide-ranging, time-consuming and transformatory changes in institutions and practices on an ongoing basis. Does, however, human rights law somehow require of Israel a role also in building up human rights in the areas under its control? And does this prevent Israel giving up that control in favour of the Palestinians? This issue was discussed in a case about the UK in Iraq called Al-Skaini, which went through the English courts and ended up at the European Court of Human Rights in Strasbourg. In that case, when it was going through the English courts, the UK government argued that the requirements of human rights law presuppose the exercise of full civil administration in order for them to be fulfilled. It was argued that because of this, the test for the application of human rights law extraterritorially has to incorporate within it the capacity to exercise civil administration. In other words, if human rights law applies extraterritorially, it requires things of the state that necessitate a civil administrative power. In consequence, human rights law should only apply to extraterritorial situations that involve a foreign state exercising that kind of power. The UK government argued that as it was not engaged in this kind of activity in southern Iraq, the area at issue in that case, then its human rights obligations should not apply to it there. These arguments found some favour with some of the judges in the English court's decisions in that case. Lord Justice Brooke, in the Court of Appeal, stated that, and I quote, "British military forces have no control over the civil administration of Iraq. In my judgment, it's quite impossible to hold that the UK was in effective control of Basra City for the purposes of European Convention on Human Rights jurisprudence at the material time. If it had been, it would have been obliged to secure everyone there the rights and freedoms guaranteed by the Convention. One has only to state this proposition to see how utterly unreal it is. The UK possessed no executive, legislative or judicial authority in Basra City other than the limited authority given to its military forces. It could not be equated to a civil power. It was simply there to maintain security and to support the civil administration in Iraq in a number of different ways." End of quote. In a similar vein, Lord Brown stated at the House of Lords stage of the same case that, and I quote, "Except where a state really does have effective control of territory, it cannot hope to secure convention rights within that territory." End of quote. Now actually, as it turned out, and indeed as some of us were pointing out at the time, the capacity to exercise civil administration is not actually a requirement for the test of applicability of the European Convention on Human Rights, as ultimately was held when that case went to the European Court of Human Rights in Strasbourg. But these statements do require us to ask, does the substantive effect of having human rights law apply extraterritorially require of the state civil powers in order to fully implement the applicable rules? And if this is the case, then either, in the first place, the trigger for applying human rights law should require this as part of the test, and therefore the rules here need to change, because at the moment they put states in a position where they're obliged to do things that they don't have the power to do. Or, in the second place, alternatively, the effect of human rights law is to oblige a state acting extraterritorially, if it doesn't exercise civil administration, to somehow deepen and extend its presence so as to be in the practical position to be able to fulfill all the requirements of the applicable rules. However, these arguments are based on the mistaken idea that the application of human rights obligations has an identical effect in terms of the substantive policies required extraterritorially as territorially. If indeed human rights law somehow required a state to govern occupied territory in exactly the same way that it governed its own territory, then indeed one might plausibly see the exercise of civil administration as an essential prerequisite for such governance. But as I've explained, human rights law does not operate in this way. Because, for example, in the case of Israel's presence in the Palestinian territories, the exercise of authority is illegitimate and must end precipitously as a matter of the self-determination entitlement, Israel's obligations while this authority is exercised are limited in that they should never require anything of Israel which necessitates the retention of control, or, put differently, that the ending of the occupation be prolonged. This is then a very different set of requirements from those which apply to a state in its own territory, where the continuance of its authority is presumed, and the substantive obligations are therefore in step with this, including measures which presuppose and require an ongoing presence. Instead, in the extraterritorial context, as in Israel-Palestine, Israel is under an obligation to make the best short-term efforts it can within a temporary framework. Equally, Because as a matter of the law of self-determination, Israel has no entitlement to exercise authority in the Palestinian territories, its human rights obligations require it to defer as much as possible to the views of the Palestinian people and their representatives, insofar as the obligations incorporate within them an appreciation of the local context. In important respects, then, the obligations are of restraint, given that Israel has no entitlement to govern, when compared to the position of the state of Palestine, who, because of its link to the local context, would be in a different normative position when it comes to rules that include accommodation with that context. But what about a situation before the transfer of power, or in a situation where power is only partially exercised, where the extent of the lack of power in this regard is bound up in the exercise of power by Israel? If the Palestinians have a right to live under a structure that is effective in securing their rights, two interrelated questions present themselves. First of all, is Israel obliged to retain power in order to build up a situation of human rights protection in the areas under its control until things are in full compliance before handing over control to Palestine? In the second place, does human rights law require that the transfer of power by Israel be somehow contingent on Palestinian capacities to effectively secure rights? Certain human rights obligations, notably in the sphere of civil and political rights, must be implemented immediately, whereas others, notably some in the area of socio-economic rights, can be implemented progressively dependent on available resources. So at least as a matter of those obligations that require instant implementation, does human rights law require Israel to retain control insofar as Palestinian capacities are deficient in this regard? Now, a general consideration needs to be borne in mind here before the two scenarios are addressed. It's significant that Palestine has acceded to the main human rights treaties. From the vantage point of human rights protection, then, the obligation to transfer authority involves Israel handing over control to another state that, like it, is bound by human rights law. So as far as the first question, then, is concerned, if the area in question needs broader structures of human rights protection building up, implicating an obligation in human rights law to do so, then a transfer of authority from Israel to Palestine is simply a shift in the obligation holder. As long as there is a state in control subject to the obligation, the integrity of the obligation is preserved. Israel's obligation in this regard is not therefore violated by its transfer of authority to Palestine. As for the second question, in most instances, whatever inadequacies in human rights protection that may exist on the Palestinian control side are matched, if not exceeded, by the problems in the areas under Israeli control. In such circumstances, then, the transfer of authority would not lead to a worse situation. But insofar as the situation might be worse in certain areas, then it would be the case where human rights will be violated in either scenario. The retention of control violates self-determination. The transfer of control would violate human rights norms in other areas. However, the jus cogens nature of the self-determination entitlement would mean that, in general, the preference for a system operated by Palestine would prevail. On the whole, any relative deficiency in Palestine's willingness and ability to secure rights, when compared to that of Israel, is treated legally as still ultimately secondary in terms of the normative position to the imperative of a speedy handover compelled by the self-determination entitlement. Of course, once the transfer of control has occurred, attention would then turn to the obligation of Palestine to improve its own human rights system. Also, it's notable that the experience of states that have existed for much longer than the state of Palestine, including this one, indicates that the realization of an effective functional state that can fully secure human rights, even those rights that are supposed to be realized immediately, is best understood to be an ongoing process, not somehow a fixed endpoint that is at some stage reached. In general, human rights law treats a failure on the part of a state to discharge its obligations to fully realize instantly implementable rights as a violation of this obligation only, not also as a basis for denying that state the right to exercise authority over its territory in favour of the authority of an outside state. An important potential exception to what I've just said would be in circumstances where the human rights deficiencies on the Palestinian side would themselves constitute violations of Jos Coben's norms, which would cover the prohibition, as I mentioned, on torture, inhuman and degrading treatment. Here, an unavoidable normative clash would present itself, with a Jos Coben's violation at risk, whether control is retained or transferred. Both states would be under an obligation, individually and collectively, to take steps to resolve this situation, derived from their connection to their corresponding violations. Palestine would have to improve conditions to remove the risk of the violation, with the awareness that at stake was not only its own compliance with its own human rights obligations, but also the right of the Palestinian people to have control transferred to Palestinian hands. Given that a lack of improvement on the Palestinian side would necessarily place Israel in the position of either violating its own Jos Coben's obligation to transfer power, if it retained power, or being complicit in, and therefore itself partly responsible for, a separate violation of a Jos Coben's obligation by Palestine if it transferred power. Given this, Israel would be under an obligation to make the best efforts to engage with and provide support to those relevant to the issue on the Palestinian side in order to effect improvement. What if Israel, as it has done for the past 50 years, retains control in violation of its obligation as a matter of the law of self-determination? That other areas of human rights law do not require of it anything which prevents the handover of authority is not to say that, if authority is not handed over, Israel's obligations remain limited to the sort of modest requirements that would fit with a situation that is about to end. The context-specific orientation of human rights law means that insofar as control is to continue, of course unlawfully, then Israel is required to do more than simply hold the line and provide temporary protection. But addressing the consequences of this reality should not mean supporting the reality. So to conclude, I've tried to demonstrate that the idea of self-determination, rarely addressed in discussions of extraterritoriality, is actually fundamental to a proper appreciation of how human rights obligations should be understood in this context. Discussions of the regulatory framework for occupation situations, including the 50-year occupation of Palestinian territories by Israel, have focused predominantly on occupation law and proceeded from this to view human rights law only in a similar situation, in a similar fashion to occupation law, as something which only regulates a phenomenon when it happens potentially making it less oppressive, something which is, of course, disputed, but does not also offer an existential challenge to its very existence. Of course, some have argued that occupation law, in supposedly assuming that occupations are temporary, does somehow imply that, in consequence, occupations have to come to an end. While this attempt to put all efforts into the law of occupation ignores, is how human rights law, through the law of self-determination, already provides a normative basis for opposing occupations. In ignoring the existential significance of this aspect of human rights law, the implications for it for the substantive meaning of human rights law extraterritorially, as something very different from its meaning territorially, is also missed. In this 50th anniversary of the occupation of Palestine, and the international human rights treaty bodies now moving into a consideration of the human rights situation in the Palestinian territories in a new normative climate where both states are bound by human rights law, I would hope that they will not only move beyond the conventional predominant focus on occupation law, we can assume this, they are after all human rights law bodies, but also that they will appreciate, as human rights bodies often do not, the significance of the self-determination entitlement to the inquiries that they're engaged in. Thank you.
Thank you, Ralph. Extremely thought-provoking, and we can really feel that you have given many thoughts to these fundamental issues over the last years. And actually, it's a very nice, provoking invitation for us to revisit some of our very traditional legal categories. So thank you very much. I'm sure many people in the room have been provoked. We have 40 minutes for discussion, so that's your chance. I mean, I have 4 or 5 questions, so I can easily abuse my position and ask them, but I think that's not my role tonight. So any question from or reaction or criticism or expression of anger from the audience. So the floor is yours. Well, I'll start while they warm up. And I'll start, you have provoked me, so I'm going to provoke you.
Okay.
And we may fake a debate even if we agree with one another at the end of the day, but this overlapping responsibilities, this idea of overlapping responsibilities, raises the question whether Palestine, I told you I was going to provoke you, is actually the right case study. Because over there, the sharing of obligation is very, very formally organized. You have this fragmentation of the territory between zone A, B, and C. You could say that, in a way, there's a bit of overlap in B, but at the end of the day, things are pretty clear-cut. It's a clear cut between the responsibilities of each of the stakeholders. So my first question would be, and I know you will easily rebut this, but so naively, I come to wonder, is that the right case study? And maybe the second comment I have, don't worry, I have half a dozen more in reserve in case these guys remain very cold. The second comment I have is, you say that human rights would not apply in the same way extraterritorially. They will not apply in the same way as they apply territorially. And so in a way, the content of the obligations will vary according to the way or where it is applied, territorially or extraterritorially. So that brings me to think that you actually reinventing the content of human rights. So behind your research on this overlapping of responsibility, I wonder whether there's not some sort of a hidden grand reinterpretation of the content of human rights. So that's just to kick off the discussion. You may wish to take these 2 points first, and then we'll go back to the audience.
Okay, so to take the second point, yes, regardless of overlapping responsibilities, so in simpler situations, which I actually don't think Israel-Palestine is, but sort of assuming that it is, so say for example Area C, it's very clearly sort of overall Israeli control, then indeed the obligations are profoundly different, and that is what I'm arguing as a sort of general matter, because of the profoundly different political relationship between a state and people outside its territory. We have to understand the nature of human rights obligations beyond sort of core protections profoundly differently. Why do I say that? Because read into much of this substantive law and how it's been interpreted has been an appreciation of the domestic context. And insofar as the substantive norms are, in the way that they have been elaborated, bound up in that context, the logic is inapplicable. So indeed, things have to be thought of very differently. And I think we're only at the beginning of doing that. The cases are only really at the beginning of doing that. And I would say partly because the very legitimacy of extraterritorial action in the first place is, of course, questionable in most cases. And whereas 100 years ago, in the era of the mandates, foreign rule by certain states was regarded by international law as entirely legitimate, because of that it was possible then for states to conceive of international mechanisms that would then seek to regulate this activity, because those mechanisms assumed that this was a normal arrangement and a legitimate arrangement. So for example, and now I'm talking, reaching back into sort of my earlier work on trusteeship over people, then we have developed this notion of trusteeship as a conceptual basis for understanding what the rights and obligations in these arrangements should be. However, since then, we've had the self-determination entitlement, which entirely repudiated these arrangements and which places the legitimacy of any extraterritorial arrangement in question. Now, of course, that's questioned normatively in different ways. And that's part of the problem, that there is no unified model, whereas there is a unified assumption of legitimacy territorially. The ideas of legitimacy of extraterritorial action are multiple and varied. Extraterritorial actions involving states taking action where they've been invited by the host state, where they're taking action that is aimed at a whole range of different policy objectives. And so the understanding of human rights obligations then has to be different to accommodate that profoundly different context. So yes, that is what I'm saying in this particular discussion and more generally in my project. And already there are some outputs available on the project website which discuss some of these issues, and there's more to come. On the issue of is Palestine the right case study, in that presumably what you're saying, if I'm not sort of caricaturing it, is, you know, there's been the withdrawal from Gaza, and then there is this division of authority between Area A, under the authority of the Palestinian Authority, B, where there's mixed authority, C, where it's exclusively Israeli control. Therefore, really, it's only B, where there is a situation where responsibilities have to be understood in an overlapping fashion. The first thing to say is, in many ways, what I was talking about today was a sort of prior question, which raises issues that do implicate the broader situation, notably, for example, Area C and Area B, right? So this question of the obligation to give up control. But also, it's important, of course, to move beyond notions of understanding responsibility only in terms of effective, direct, boots on the ground territorial control, and think about the various ways in which human rights can be affected by states in broader circumstances of causal relationships. And it is, of course, ridiculous to think about the human rights situation in Gaza and not somehow accept that in certain respects that is affected by the actions of Israel, even despite the formal end of the occupation of Gaza. So if human rights law is to be attempting to regulate the exercise of power by states that plays a determinative role over human rights outside their territories, then it will have to come up with, and there have been certain cases that have attempted to do this, tests for applicability in regimes of responsibility that can account for a more complex power dynamic that would conceive responsibilities, for example, on the part of Israel in relation not only to Area C and parts of B, but also the other parts of B not under Israeli control, and A and Gaza.
I really like, so I see many hands, I really like your challenge. I see 3 already. Let's take actually 4. Let's take 3 questions after this, but just one comment. I really like your challenge of this traditional boots on the ground approach, the effective control doctrine. I think that's going to be a major contribution to legal thought and practice.
Can I just jump in there and say I must emphasize that actually what I'm saying here will be, I have said this already, but it's going to be elaborated further, that actually there is a way of defining effective control that is broader than boots on the ground. So there is a sort of, so the two are not entirely coexistent. Sorry.
No, which is
it's just very important because that has been accepted in the case law in this area, but there are other ways. There are also ways of thinking about effective overall control that would encompass other forms of authority other than those involving a direct.
Yes, so repudiating the Bankovich and Loisidou approach. So you're not going to make
not repudiating. Well, no. Actually, within the contours. I mean, Strasbourg has itself moved on from Bankovich. Bankovich was the decision about the NATO bombing of Serbia in the 1999 in the context of attempting to deter Serbia from human rights violations in Kosovo. One bombing incident, was a radio TV station in Belgrade, killing people in the TV station. The relatives of the deceased brought a case against certain NATO states to the European Court of Human Rights, where the court held that mere aerial bombardment didn't constitute effective control for the purposes of the application of human rights law. In many ways, though, the development of this area of law since that decision, a decision that came at a particular moment in the political context there where the attacks on 9/11 had happened, the invasion of Afghanistan was about to take place. There was arguably an unwillingness on the part of a human rights body to go into the business of adjudicating on the legality of the conduct of armed hostilities. And what we see in the war on terror decade since then, with the invasion of Iraq, with the abuses of Abu Ghraib, with Guantanamo, etc., and now, of course, drones, is arguably a greater willingness on the part of international human rights tribunals to exercise scrutiny over those situations. And the Al-Skeini decision, sort of 10 10 years plus later, at the European Court of Human Rights, affirming the extraterritorial application of the European Convention in Iraq, in many ways is really marks a shift from the Bankovic approach. And one wonders then whether the court would make a similar decision now as it did then, and whether we might. There are also other decisions about Northern Cyprus, where acts of shooting have somehow been constituted the exercise of jurisdiction. So if shooting is jurisdiction, then perhaps bombing is also. So a broad adoption of effective control, which does not require a presence on the ground. Clearly, as a matter of logic, the notion of dropping a bomb on someone and killing them would, by most reckoning, constitute the effective control over that person. Part of the problem with understanding it for the purposes of applying human rights law is what I mentioned in the talk, the concern that somehow triggering the application of human rights law would then require the state to somehow implement all of the human rights obligations in the Human Rights Treaty in the area in question. And that somehow a context-specific meaning of those obligations could not be applied. And obviously it would be ridiculous to suggest that by a moment of aerial bombardment, somehow those states are then obliged to secure all of the rights, say for example in the European Convention on Human Rights, in the area under question. Arguably, that's not what human rights law would require, and therefore that some of the fears about the consequences of extraterritorial applicability are unfounded. Sorry, John.
Yeah. No, I think that's very useful also because there are many students in the room and they're currently studying these issues. So this is extremely useful, and I'm very thankful you taking pains to reintroduce these important reminders. But can you have overlapping responsibilities if the obligations are different? Say if the content of the obligations for Israel is different from the content of the obligation of the PA, is that overlapping? And then I will take the three questions. I have Anton, I have Dixon, and I have Mary.
Well, I think that it will be a situation where some of the substantive requirements. This is now a lawyer's answer, right? But the context will be key. So you might have a situation where there are mutually exclusive requirements, and each state is obliged to do something different because the circumstances dictate. In other situations, it might be that both can play a determinative role over the same situation, and therefore it would be more by way of an obligation of cooperation. And there are situations like that. I was just in Jerusalem 2 weeks ago, and that is very much an issue. There are lots of areas where at the moment problems arise because of a lack of cooperation, where any given individual situation is affected ultimately partly by the actions of one and partly by the actions of the other.
Mm-hmm.
So we'll take three questions together. Antal, please introduce yourself.
It's Antal, but it's really encouraging, and generally in your presentation is that you show very clearly through the example of self-determination that human rights law does oblige even states, even such highly politicized domains as their foreign policy, and even moreover the heart of their foreign policy. And does this logic apply to situations of occupation where not state A occupies state B, but just a part of the territory of state B, where there is no clear self-determination issue, or at least arguably no clear people subject of self-determination? I doubt whether in those cases, international human rights law and human rights bodies oblige the occupying state to at least to change the occupation or shorten the occupation. At least I do not see how they pretend.
Okay,
So,
yes.
But certainly for the home state, I think it's very clear that's the case. The home state, the territorial state is obliged even more and more in its foreign policy.
Can we take several
Yes.
questions?
Yes.
Dixon?
Yeah, Dixon Wasaji, I'm a PhD student here. So I want to thank you for that cogent presentation. I want to imagine myself as a stranger who has just listened to the 5 o'clock news on Radio 4 as I was driving through this place. And there is a question of Catalonia and Spain, and find myself straying in this room, and the mention is self-determination as an entitlement. With your reserve of wisdom, if I were to pose a question to say, could you distinguish for me what the situation is, say, which is just next door here in Europe, or self-determination of the Catalonian people and that of Palestine in relation to the international human rights question. Another brief question is about the historical injustice that the people of Palestine have suffered for the past 50 years. Should we invent or elevate self-determination of such historical injustice to the use cogain status, whereby a state cannot derogate on another part of this planet to self-determination?
Thank you. Mary?
Thank you also. I really appreciated the context-dependent interpretation of human rights obligations when you're told. I wondered, I'd ask the Tokonon whether there is some vulnerability in the program that you suggest to becoming a program at times, not always, of support of havens for failed states or exploitation and corruption within countries, within territories which have been occupied. I was struck, for example, that in talking about self-determination, there's a kind of capacious use of self-determination, where at times it almost seems that governance within national boundaries is self-determination, if it's by some actor within that frame, as opposed to some more genuinely democratic or representative kind of arrangement. It also seemed at times that being a signatory to the Human Rights Convention elided into adherence to and the development of institutions for human rights. Now, it's clear that exceptions were drawn, and caveats were made. For example, if Palestine is deficient, if Palestine is deficient, it creates a dilemma where Israel either resists or is complicit. And so at times there's a recognition that, for instance, in Palestine, self-determination is problematic in many ways, that torture may be part of the picture, that strong factions and weak institutions and terrorist activity are all part of the picture. But I'm not sure if the set of obligations and the position of the occupying nation is fully protected against that. And I wonder if you could reflect on that a little bit.
So back to you, Ralph.
Great question, really important for the topic. Thank you very much. So, self-determination. And forgive me, I should really just sort of go through some of the basics. So there's a difference between, in the first place, internal and external self-determination. So external self-determination being the right of a group to potentially determine their external international status, including becoming a state. So that's the sort of Catalonia type scenario. And indeed what the Palestinians also aspire to that. Now, who gets that right in international law, whether or not this is something that is politically supportable? What the law says is that it's a very narrow class of groups, and beyond the colonial context, it's hugely disputed as to whether, on an ongoing basis, other groups get this right. Now, one of the occupational hazards of being an international lawyer is, of course, that you are expected to know the ins and outs of every single territorial dispute in the world and the particular merits or otherwise of every single group's claim to self-determination. I'm going to avoid pronouncing upon the Catalonia situation, but I would just say that in general, outside the colonial context, the main route to an external right to self-determination is arguably, potentially, and even here it's uncertain whether this is where the law has got to, but it may be where the law is going, a situation of a flagrant violation of internal self-determination at the level where potentially a particular group faces a threat to its very continued survival. So, for example, the position of the Kosovo Albanians in the period running up to and during the NATO bombing campaign that I mentioned before. So I'll leave it there as to whether that sort of where Catalonia fits within that. But beyond question, the Palestinians are entitled to this right. Because the mandate of Palestine is a class of, essentially the mandates were a type of internationally supervised colonies. They were the colonies of the defeated powers at the end of the Second World War, which were placed under international supervision through the League of Nations as mandates, essentially as colonies of the victorious powers. So Palestine became essentially like a colony of the United Kingdom, but subject to this unusual special regime of international supervision. The mandates, the trusteeship territories, which are also similar arrangements after the Second World War, and other colonies were all treated collectively as being populated by people with this right to external self-determination. Indeed, external self-determination in that sense was conceived as a means legally of bringing about that political aspiration which after the Second World War it was accepted was applicable to them. What then is so the Palestinians are of a narrow class of people in the world who still do not have that right fully realised. People who have the right based on the colonial, original colonial formulation. The Western Sahara would be another one. Of course, East Timor was a long-standing case until the independence of that. The people of East Timor not that long ago. So the question then is, what does self-determination mean beyond that on an ongoing basis? And what does it mean as a human right? It's in the Human Rights Covenants in Common Article 1. the position I would take is that it retains its significance for people within a state. Partly it has an internal manifestation, and there's a huge discussion there, which I'll need to come back to in the context of the other question, about whether it somehow provides for standards concerning governance within a state, and of course the work of Tom Frank, dear Tom, friend to many in this room, his work on the right to democratic governance in international law. But it also involves a right, again, on an ongoing basis of freedom from outside interference, notably in the context of territorial control. So that's what links the people of Iraq in 2003 with the Palestinians since 1967. Of course, the people of Iraq had a state, but then it was subject to a foreign occupation. And arguably that right to be free from foreign occupation is an ongoing one, and one that potentially is applicable not only to the entire population of the state, but also if part of the state is under foreign occupation. So Antal, I would say therefore that it is applicable to those situations, not just in situations as it were a plenary occupation like Iraq. Does then what I've been saying reinforce because it's sort of agnostic on the quality of governance in the occupied state, that therefore will potentially reward oppressive governance by somehow obliging a foreign state to give up control to an authority that is itself problematic in whatever way, including the ways that you described. And from the perspective of self-determination, the problem, of course, is that outsider administration is by definition illegitimate. So, yes, to use another example rather than Israel-Palestine, the government of Saddam Hussein in Iraq obviously was an oppressive regime for many people in that state. That does not mean that the occupation of Iraq was not also problematic as an outside imposition. They're both problematic, and they're both in different ways a violation of the right of self-determination of the Iraqi people. So in that situation, the foreign occupier has an obligation still to give up control, of course to make best efforts to ensure that that's done in circumstances where there will be a regime that is compliant with human rights and enables self-determination. But ultimately, as far as its normative position is concerned, the issue, the existence of its presence remains problematic, irrespective of the nature of the regime it would transfer authority to. International law, for better or worse, deals with that through the obligations that are then applicable to the host state. As I mentioned before, international law does not contain a general doctrine that states lose their entitlement to be free from outside interference simply by virtue of the quality of the governance provided in that state, what you called a failed state idea. The international law after the Second World War, through the rules on non-intervention and the rules on self-determination, have constrained the possibilities there so that outside intervention, interference and administration is now only justified in very narrow circumstances, essentially of self-defense. And so what you're talking about would require the broader normative framework to accommodate, for example, humanitarian intervention, because this is really sort of the logical consequence of what you're saying, is that states should, if the quality of governance within a state is problematic, that then other states should have the right to intervene to bring that situation to an end. And that's really a broader normative question of the international law on intervention and the use of force, as well as what I've been talking about today, which is human rights law and the law of self-determination.
I accept everything that you've said regarding the state of the law and the issue of rather normative consideration. And that's really why I asked you to reflect on whether there's something problematic in the law as it currently stands.
Yes, well, I think
this political.
I think that the lessons that I learned from the history of trusteeship over people. So what you're advocating or speculating about whether this might be possible, when 50, 100 years ago, this was entirely accepted as part of the international normative framework. That's why, indeed, Balfour felt entitled to pronounce upon what the future of the Palestinian mandate should be, out of a sense that it is entirely appropriate for him in London to make the best decision and the best judgment about what is in the interests of the people of that region and people more generally. Now, I think as the Balfour Declaration kind of indicates, all of that history, and one of the central reasons for the delegitimization of colonialism and imperialism was, first of all, the notion that there are some people in the world unfit to run their own affairs, and there are other people in the world who somehow are fit to make general decisions of this kind. That was repudiated. But also, even within the logic of trusteeship, within the logic of paternalism, there was this constant criticism that in its actual instantiation in practice, it was usually practiced in bad faith. And so it was always exploitative, it was always a cover for something else. And so it's very important when these issues are discussed, is that the actuality of instances where this has successfully been implemented and not been corrupted by the self-interest of the actors engaged in these operations. And for many people, that was regarded as one of the central reasons for opposing this regime. So it's a sort of pragmatic idea that it may sound appealing in theory, but in practice, it involves decisions and actions by self-interested actors who are also not subject to effective checks and balances that hold them to the ideas they're supposed to be following. So the problem with trusteeship was not only the problem with trusteeship itself, right, that there should be no people who are adults and children in the international normative system, but also even within that logic, that trusteeship was constantly, the trusteeship obligation was constantly violated, and there was no effective international mechanism for ensuring compliance. And the mechanisms that were created, like the mandates system, were not effective.
Could I just quickly come back on that, which is to say, I agree with you completely about the sad history of the assessments of fitness to belong to the family of civilized nations, and the ways in which that was tainted by interest historically. I wonder whether, in today there's a new standard which is not fitness for membership in the family of civilized nations, but systematic abuse of basic human rights, including the right to life and to avoid torture.
Absolutely right. So now the argument is, and this has been around for a while, that human rights are the new standard of civilization. Right? So whereas before we had the standard of civilization was compromised, it was essentially a racist idea that didn't have universal purchase. Now we have these global human rights instruments which have been universally accepted and therefore provide a normative basis for this idea of trusteeship which didn't exist before. There are huge issues with that idea, right? But even sort of accepting that, as you seem to do, we're still left with the problem of, which is what I was talking about, which is the bad faith of the people who are making judgments about who requires these arrangements, but then also when they carry them out, the judgments they make about when people are ready for independence and on what basis. And that remains a problem. Even if you take the view that there is some globally accepted standard, the actors involved in adjudicating that standard and implementing it are not selflessly independent from international power, politics, and the interests of states. They are those states whose self-interest and exploitative behaviour is one of the reasons why colonial trusteeship was delegitimised.
Thank you for this very insightful exchange, and I think your comment on the Balfour Declaration is probably an appropriate way to wrap up our conversation, because this is how you started tonight, 90 minutes ago. So, because it is, ladies and gentlemen, 6:30, I have to bring this to a close. This has been a very, at least in my view, absolutely fascinating discussion. I'm very happy about all the reminders you've provided, because there are many students in the room. It's very helpful for the degree. Please note that the lecture will be online sometime soon, probably in two or 3 weeks, on the web pages of the Manchester International Centre, where you can also find recordings of our recent events. You are not all invited to a very small and informal reception where you'll get the chance to ask questions, further questions to Ralph, even if you should let him rest a little bit. But please, before I wrap this up and bring this to a close, let's give a hand.
Can I just say one thing? Sorry, just for the recording. I think I made a mistake in one of, and for everyone here, I think I got my cases mixed up. Anton, maybe you can help me here. I think I maybe said Isa instead of Ilascu.
Yeah,
so the case that I was mentioning about Russia and Moldova is called Ilascu. It's not called Isa.
You see